Hello and welcome to this fourth edition of our webinar series on POPIA. Sorry for a bit of the late start. We had some technical problems. There's currently a huge storm that is just passing by. So hopefully we don't have any issues from a connectivity perspective. If we do, and if I disappear or one of us disappear, the rest of us should be there. Please just hold on, we'll be back. And so today you've got myself, John Giles. You've also got Bronwyn Seeger, one of our attorneys. Bronwyn's going to be assisting us with coordinating the questions from today, which we're expecting quite a lot of interaction on the chat functionality and also in the Q&A. Bronwyn is very involved in Scouts, and because of that, she's very good at problem solving, very good at working in a team, and it's fantastic to have her as part of the team and on the call today. And then Mark Hank, I think you know Mark as well, and no further introductions required there. Just seeing, sure, lots of people have poured in. We're at 250. We've got over 400 people registered today, so we've got a large group, which is really fantastic. And today is all about you and your organization. We are going to try and do an impact assessment on what is the impact of POPIA on your organizations. And we're going to try and do it as a group with close on 300 different people, which is going to be a challenge. But it's an exciting opportunity, and I think will be a really nice thing to do with a large group of people. So I think without further ado, we should kick off. I'm going to share my screen, and we can start. So yeah, we've got our normal standard presentation here, and we're going to be under the introductory section. We're going to be looking at your organization. And we're going to look, as I said, about an impact assessment. So this is part of considering what your organization's strategy is, how ready you are. But the first question really is around what is the impact on my particular organization? And so we are going to do this impact assessment, and we call this an organizational impact assessment. In other words, it's what is the impact of data protection on your organization? And really the key point here is that there is no one size fits all. The impact is different for different organizations. And because of that, we really need to do this exercise, because depending on the impact depends on what you're going to do. So you really need to understand what the impact is on your particular organization. All right. And then what I wanted to also cover at the beginning of today's session is really saying what this isn't. And this isn't a readiness assessment. That's how ready your organization is. It's not a risk assessment. So actually, maybe let me go out here and zoom to the different parts of our presentation. And so under Learn is, well, sorry, before we do that, so under the intro, and under this section about you is where you do a readiness assessment. Under Learn and the risks is where you would do a risk assessment. And then under Plan is where you would do a gap analysis. And these terms all sound very similar, but they really do have a significantly different meaning. We've researched them in detail, and they really do have different meanings. A gap analysis is very different from an impact assessment. So it's part of planning that you do a gap analysis. And then as part of actually protecting information, this is where you do a privacy impact assessment or a PIA, or what it's also called in POPIA is a personal information impact assessment. Now, this terminology is really tricky, and I just want to pause on it for a second, because a PIA, so privacy impact assessment, or a personal information impact assessment, is asking what is the impact of your activities on people's privacy. what is the impact of your services or products on somebody's personal information? That's what that type of impact assessment is, and they're required by the GDPR and POPIA regulations. So you have to do those by law, but that's part of actually protecting information. And the classic scenario is, let's say you've decided that you are in insurance and you're going to start a bank. You need to do PIAs on that new product, the new activity that you're conducting, and the emphasis being on what's the impact of this new product of ours on people's privacy. So that's that kind of PIA. That's not what we're doing today. Today, we're considering what is the impact of POPIA on your organization. So it's quite similar, but it's an important distinction that really is worth making. And then the last is that under sustain, and for us this is at the end of the process, is where you would do an audit. And so you've got assessments often at the beginning, you've got then gap analysis to plan what you're going to do. You do assessments as part of complying, and you do an audit at the end. So I know it's confusing, it seems a bit crazy, but that terminology really is what's used internationally. Great, I can see that we've got some questions coming through, so please keep those going. Bronwyn is going to be monitoring those and responding on the chat box. So let's then go into the introduction, and let's go into this slide over here. And so what the format of today is going to be is that we're going to ask a series of polls, and really the questions on the screen that you've got in front of you relate to your organization, your organization's role, the personal information you process, your customers, your employees, your suppliers and processes, and your laws. And we're going to ask you at the beginning what you currently think the impact is on your organization. We're going to then run through those questions, and at the end, again, ask you what you think the impact is on your organization. And we're really trying to help you to get to a point where you know it's high, medium, or low, and potentially also where specific areas, so the impact might be low, generally speaking, but you might have a high impact in one particular area. And that's what we're trying to achieve in the next half an hour or so. And we'll then switch across to Q&A after about half an hour or maybe 40 minutes, depending on how we go. So please be very quick in responding to the questions. There are lots of polls we'll be dealing with. And let's start, unless Mark or Bronwyn, you've got anything you'd like to add.
John, I think let's go ahead.
All right, so I'm going to launch the first poll. And the question here then is, what do you think the impact of data protection law is on your organization? If the poll hasn't come up yet, then there's an issue. Let me try and resolve it. Yeah, for some reason, I can't launch the poll. Mark and Bronwyn, are you currently seeing a poll, or are you seeing still the presentation slide?
No, John, I'm not seeing the poll. I don't know whether Bronwyn can launch it.
Yes, John, I think I can launch it.
So if you can launch poll 1. Oh, there we go. It's just started, I think. Perfect. So if you could answer that, what do you currently think the impact of data protection is on your organization? Thanks. The votes are coming in thick and fast. So obviously this is going to be interesting to see if it changes by the end of the presentation. And yeah, it'll be fascinating to see if we're able to guide people. I'm also interested in how many people don't know. Hopefully by the end, we don't have anyone who doesn't know. That's great. Thanks for the answers. I'll end the poll there and let's share the results. Yeah, so 62% of you believe that it's high, 30% medium, only 4% low. Cheapest. So really most people think it's high or medium, and then there's 5% who don't know. So hopefully we can help those that don't know, and let's see if that changes. Maybe let's jot down those numbers. So it's 62, 29, and 4. Let's see what my memory is like. Okay, so then let's go to the next poll, which is about your organization. And I'm going to now ask, there are 2 questions here to answer. The first question is, what is your main activity, or what industry are you in? And I only had space for 10. And so I had to pick the things that I thought were most relevant. If they are not there for you, then please tick other. And maybe you can also pop them in the chat box if you want. And we can get an idea then in the chat box of what industry you're in. Yeah, sorry, I mean, it really, I know there are obviously many more industries, but that was the limit in terms of options that I could give. And then the second question is about what do you roughly estimate your annual turnover of your organization to be? That's also very useful as a factor in determining the impact, because the larger your organization, generally speaking, the bigger the impact. There's, even if the impact is low, let's say you are a manufacturer or you're a mine that processes very little personal data. The fact that you're a large organization that's multi-jurisdictional definitely increases the impact and the difficulty in responding to POPIA. So thanks. I think let's leave that there, and I'll share those results with you. So I'm definitely having a few connectivity issues. Bronwyn, maybe can you end the poll and share the results?
Sure, John.
There we go. So we've got 20% of people are financial services. So financial services there's a big impact. Obviously, there's lots of personal information, lots of interaction with data subjects who are natural people. We've got 8% in healthcare, and also that's high impact because it's health-related information. We've only got 3% in marketing and direct marketing, but that is a high impact area. We've got some in retail. So retail, generally speaking, the impact there is obviously with customers and dealing with customer information. And also there's an impact with suppliers as well in the context of retail. And marketing is obviously a big deal in a retail context. And then insurance is also high impact. There's lots of personal information involved. There are many of you in IT and telecoms, and generally speaking, it's also high impact. So manufacturing is lower impact. Education is also high impact in that there's often lots of information about children or learners, lots of personal information about parents as well. And then we've got some non-profits as well. So quite a spread there about different industries. And then in terms of size, most of you, 40% are large, above 50 million, but we do then also have some smaller and medium-sized businesses. So generally, we speak of a small business being up to 15 million, 15 to 50 being medium, and above 50 million being large. But that does vary quite significantly. So one key point here about the turnover is that the exemptions for POPIA manuals are based on number of employees and your turnover. And the table it varies by industry. Some industries it's 15 million, some it's 25 million, some it's 50 million. So to check whether you're exempt from having a POPIA manual, you actually have to go and look at that table, work out what industry you're in and what your turnover is, and see whether you're exempt or not. And that information is on our website. You can go and have a look at that if you want to check whether you're exempt from having a POPIA manual. But yeah, so that's a little bit about your organization. We'll talk about the impact in different contexts, but that's that component of it. All right, so the next poll is about the personal information. Sorry, no, it's about the role that your organization plays. And let's launch that one. So we spoke about this 2 webinars ago. Was in the overview, we spoke about the fact that there are 3 role players: the data subject, the responsible party or controller, and then an operator or a processor. And it's really interesting to get an idea of what role you generally play or primarily play. You're obviously going to be playing multiple roles, but which is the primary role that you play? So most of you are saying that you are the controller or the responsible party. And so the impact is definitely bigger on the controller or the responsible party because they're the one who needs to comply and they have most of the obligations. They are accountable and responsible. The processor still has things to do, but it certainly is the controller or responsible party with the lion's share of what needs to happen. So if we end that poll and share the results, 44% are controllers. Yeah, so this is very important. And, we spoke about it in the overview. You have to know when you are the controller, when you're the processor, because it can change in the context of different activities. And there are different things you need to do based on what role you perform. It's interesting that 21% say you're joint controllers or responsible parties. I think in my experience, often people think they are joint, but they're not actually joint. And I think that's almost a case of being jointly and severably liable. It would be preferable to be clear that you're either a controller or a processor. And then there's some people who are saying that they're not sure. So it's important that you clarify that. So if you're not sure, yeah, there are different ways of achieving that. The one way is that we do offer a responsible party assessment where we help you to assess and determine whether you are the responsible party or not. The other way would be to join the program and to work through those modules about the role players, which will help you then to clarify what role you perform in the context of different activities. But I think certainly if you are the controller, that means the impact is going to be significant. Yeah, so Mark and Bronwyn, please feel free to add as we go along. You're very welcome. Just interrupt me and add any comments or thoughts that you have.
I think one of the things, John, that is worth mentioning is when you do these assessments, don't just look at the negative side. Very often with assessments of this nature, what you're doing is you're identifying things that possibly you don't have to do. You may find, for instance, in just dealing with information, that there's some information you don't have to deal with. That you've dealt with as a legacy issue in the past, and very often, particularly with us changing to or computerizing some of our systems, part of what has happened is we computerize paper systems rather than looking at the advantages that we might get from our systems. So there are also benefits that you I think need to assess in making that assessment, because quite often the result of your assessment and what you need to do and selling the things that you need to do in some instances will be important from the point of view of just explaining to executives, etc., why you need to do it. And very often the benefits are important in making a decision in that regard.
Yeah, thanks, Mark. That's a great point. And I've done impact assessments with organizations where what we get to is that the organization has a product which is very useful in helping other organizations protect personal data. And so the impact is very positive. We're expecting that business to boom. And it's very important to be looking for the opportunities and not just the negative connotations of doing an assessment like that. So I totally agree.
I think one of the examples that is probably germane to all of us at the moment is, and we didn't have an opportunity to plan, it happened very suddenly, but is working from home. There are huge advantages for organizations, for people working at home. And until this forced experiment, if we want to call it that, came about, we weren't really looking at it. I think now the situation is that lots of organizations will probably decide, if they do a proper assessment of where they are, that there are large advantages. Some of them they might be unavoidable, and some of them may not be beneficial, but there will be huge benefits as well in looking at it properly in that context. And obviously it has an impact on how you might process personal information as well, because certain aspects of what you're doing in the workplace as opposed to home are very different. And you know, just how you structure access to certain servers, etc., can be very important, and obviously the security aspects are critical to look at as well. I think it's an example that is here and now that we could look at and probably use some of what John is talking about here to be able to make those assessments as well.
Yes, I agree. All right, let's move on to the next poll, which is looking now at the personal information that you process. And it's coming up now, I think. It's taking a bit of time, but I think it's on its way. So the questions here are going to be, do you process any of the following kinds of special personal information? And the other question is, do you process account numbers? And then also if you process the personal information of children. So I can see it's taking a while for the poll to display on your side. Bronwyn, I don't know if you're able to launch the poll.
No, John, it seems to be wanting to relaunch the previous poll on my side.
Okay, let me try. Sorry about this. I haven't experienced this delay before. Sorry, this is the wrong poll. Sorry, if you just give me a sec. Sorry, this isn't launching at the moment. So let me maybe talk to you about it while we wait to see if that will launch. So essentially the point here is to look at what types of personal information do you process. Do you process a little or do you process a lot? Obviously, if you're processing a lot, the impact's going to be a lot higher. And this is interesting. You might be a small business that sells donuts. You're going to process a very little amount of personal data. The impact, therefore, is low. And but if you are a small business that sells marketing lists or direct markets or helps people with direct email marketing, it's going to be significantly different. So the poll should be displaying now. If you could answer this poll, because the second question then is how much special personal information do you process? And essentially Parliament has said that if you process this kind of information, then you have to be authorized to do so. And this information can be used to cause a lot of harm. So if you're processing a lot of that kind of information, the impact's going to be higher. The other question is around account numbers. And I mentioned this in the overview that in South Africa, the risk of jail time or a fine is much greater when it comes to account numbers than other kinds of personal data. So if you're processing lots of account numbers, then it's going to be a higher impact as well. And I can see many of you are saying no, which is great. It means the impact is lower. There's some of you who are saying, yes, you process lots. And obviously for you, the impact's going to be high. So I make a distinction here between some organizations process a lot of account numbers just in the ordinary course of business. For example, to pay suppliers, pay employees, but that's quite ordinary. And there the impact is medium. It's not significant, but it's medium. But if you, for example, are a bank or if you are a payments processing company, then obviously that is going to be a much more significant issue for you. And then the last question is, do you process personal information of children? And we obviously wanting to protect our children from harm. So if you are processing children's information, the impact is going to be higher as well. So let's end that poll there, and I'm going to share the results if I can. There we go. So there are many of you who process race or ethnic origin. And that's probably in the context of employees and employment equity. And that is an important point to look at. A key thing there is that that POPIA actually does authorize you to process for employment equity purposes. So that is there by default. So many of you saying no to account numbers, so the impact is lower, and no to children, so the impact is low there. That's very interesting. All right, let's move on to your customers, and let's have a look at your customers. So there, that worked very well. If you could answer those two questions. And here really the point is that the more customers you have and the more they are natural people, they're humans, the bigger the impact on you. And so one extreme might be a mine who has 5 customers who are all central banks, who are juristic persons. That's a very low impact. But if you've got lots of natural people who are your customers and you interact with them a lot, then the impact is going to be a lot higher. So the results are coming in. I'll give you a little bit longer, but at the moment, most of you have 10,000 or more customers. And yeah, most of you are saying it's a combination, or you have lots of natural people or humans as your customers. And so, yeah, it's almost the B2C organizations is high impact, B2B is low impact. All right, let's leave that poll there and let's share the results. Yeah, so most of you have lots of customers, so higher impact, and most of you have natural people. So very quickly there, the key difference between POPIA and many other data protection laws is that POPIA requires you to protect the personal data not only of humans, but of juristic entities as well. And that's a very specific South African nuance that's worth taking into account. All right, then let's look at your employees. And if we launch that poll. So the two questions here are, how many employees do you have, and do you process health-related information about them? And I'm interested here, I think everyone is going to be processing COVID-related information at the moment, but I'm also interested in if you generally processing other information. So for example, let's stick with a mine. Some mines or manufacturing plants, they have clinics, and they have their employees having medical checks once a week, sometimes once a month. And they have very detailed information about those employees. And obviously that raises the impact significantly, because you then are almost a hospital, you're in the healthcare industry. And also the more employees you have, the bigger the impact, because you're going to be processing more personal data about them, and the bigger the risk if you were to have a breach. And then let's end that poll and share those results. And so it's pretty much spread in terms of the number of employees across the full spectrum. And then, yeah, half of you are processing just corona-related information, but then many of you are also other health-related information. So almost you want to think to yourself, okay, am I a standard employer who just processes standard employee personal data? Then the impact is not so high. And there's lots of things that'll help you to protect that employee personal data because you're really quite standard. But if you are lots of employees, lots of health-related information, the impact is much higher. I think, yeah, the other point here is that the number of employees can exempt you from certain things. For those of you who are in the 18 and 21%, so you're less than 50 employees, you're exempt from having a POPIA manual if your turnover is low enough. And yeah, so that's some considerations around employees. So what we're really trying to get to is to say, okay, is the impact on your customer side or is it on your employee side? And they're very different categories of data subjects and have quite a big difference on what you're going to do depending on where your impact is. So some organizations will go, oh, we've got 10 employees. That's not where our issue is, but we've got 10,000 customers who are natural persons. That's where our impact is, and that's where our focus should be. All right, let's move on to the next question. I see time's flying by, and but we've got a couple more polls to do, and then we can start wrapping up and trying to get a picture more generally about where we stand. I'm just waiting for this poll to respond. Sorry, that's taking its time. Let's just give it another couple of seconds. Hopefully it'll respond now. Sorry, I don't know why it's taking so long. Okay, while we're waiting for that, all right, so I hope you can now see my presentation again. So we've got now to the point, the questions around your suppliers and your processes. And let's see if I can launch that poll. There we go. I think we're back in business. So we're now launching the next one. So here we're asking, how many suppliers do you have and how many entities process personal information for you? So the first question is how many suppliers? They can be suppliers that have nothing to do with personal data. So the person who supplies you with toilet paper. What's interesting there is obviously you've got to pay your suppliers, so you've got to process their bank account details. So it's interesting to know how many you have, and obviously the more you have, the bigger the issue. And then the second question, it's interesting to know how many of those process personal data for you. And obviously the greater number of operators or processes that you have, the bigger the impact's going to be, because you're responsible for what they do. And you're going to have to conclude contracts with each one of them. So it's going to be a much bigger impact if you do have many. So thanks. The results are coming in there thick and fast. So I'll share the results with you just now, but we really have a full spectrum on the number of suppliers. There's really in all categories, although the most is in the 21 to 100. And then we also have most of you only have about 1 to 5 processes. So let's end that poll, and hopefully it'll work and I can share my results with you. So there you can see we're mostly 5 to 20 suppliers. So that's medium impact in that context, or even low. And then many of you only have 1 to 5 processes, which would mean you've got low impact there as well. All right, then the last set of questions is, the question is, well, what laws do you need to comply with? And if you could tick one there, and really the point being here is that if you only need to comply with POPIA, the impact is lower. It's easier to do. If you have to comply with multiple data protection laws in multiple jurisdictions, the problem becomes harder, because the question is, what do you do with the overlap? How do you ensure that you're dealing, and as we spoke about before, you're going to focus on the common 80% and then pick up the 20% or the 10% extra in different jurisdictions. But that's quite an exercise to do. It's not simple. So yeah, this is fantastic to see the results. They're coming in thick and fast. So most of you are saying just South Africa, which is interesting. I've got a word of caution here. Many people don't think they need to comply with the GDPR in the EU, but a lot of people do. And really the questions you need to ask yourself, even if you're outside the EU, so you're in South Africa, you're not in the EU, but if you're targeting people in the EU, you're trying to sell them things, or you're profiling people in the EU, you also need to comply with the GDPR. But thanks for those answers. If I'll give you a couple more seconds to look, but the overwhelming majority of you are just saying South Africa. Well, you may have ticked multiple ones, so I guess it could be multiple laws. So this is actually going to be a little bit misleading. But if I share those results with you, so you could have ticked multiple. So actually there will be many of you who are multiple jurisdictions. But yeah, so if it's just POPIA, low impact. If it's multiple jurisdictions, higher impact is essentially the point here. All right, so that's the end of those questions. And so I think what I want to ask now is, let's go to the impact now at the end. And if you could now, if you could answer this question. So after looking at those different questions and thinking about it, have you changed your mind? Do you think the impact is different to what you thought at the beginning? And let's see how that goes. I must say, I've done many of these impact assessments, and often what I find is that people think the impact is high, but having spoken about these issues and gone through these questions, we often get to, actually the impact is medium, and sometimes it's low. But there's a high impact specifically with employees and the health, or we do lots of direct marketing, or it might be that we really are low impact generally. Thanks. I'll give you. It looks like we're almost everyone has voted there. So if we share the results, we're now at 59, 31, and 8. My memory is correct. I think we've gone. There are less people who think the impact is high. There are more who think it's medium. About the same who think it's low, and there's still a few people who are not sure, but we've reduced that a bit. So if you're not sure, we could always set up a call to help you to try and clarify that. We also do offer an impact assessment where you can complete a questionnaire on our website, and maybe Bronwyn can put that link into the chat box. You can answer the questions we've been through now, and we can then set up a call to discuss it specifically with you. If you would like to get more specific discussion directly with you, obviously this has been with a group of 300 people. But yeah, I hope that's given you some of the questions and factors to be thinking about in determining whether or not, or what the impact is on your organization. So maybe, Bronwyn, can we go across to you and tackle some questions?
Hi, John. Yes, we've had quite a few questions come through. I just want to sort of have a look at the different themes. We've had a lot of questions about account numbers and what specifically they entail. So, for example, what typically constitutes an account number? Does it refer to a PIN or a traditional bank account number? You know, what if an account number is tokenized by the provider? Is it then regarded as an account number still? Yeah, if you could just elaborate more on account numbers.
Yeah, sure. So I've just shared my screen again and gone back into the facts and gone into account numbers. And essentially, it's any unique identifier that an institution assigns to a data subject, which enables them to access their own funds or credit facilities. And then here is the definition in POPIA itself, which is a little bit more confusing. And I'm not surprised there are questions. There are lots of ambiguities in this definition. It's not a very good definition, and we've spent hours debating this in the office as to what's included. You know, and exactly the questions, Bronwyn, that people are raising. Is it a one-time PIN? There are lots of, what happens if I need 3 data elements in order to access an account number? Is each one of them an account number, or collectively they're an account number? But I think the best answer that I've got for this is what Parliament's trying to do is they're trying to stop criminals stealing people's money or taking or buying using their credit. And so, and it's a noble thing to do. There are lots of people who get scammed in South Africa and have their money stolen. And so the focus should be on, well, what data and what pieces of information does a criminal need to steal someone's money? And really that's what an account number would be. And yeah, I mean, we've actually done opinions on this issue in detail, answering the nuanced questions, and there's a lot to discuss, but hopefully that's helpful, and we don't really have time, I think, to go into that in more detail.
All right, John, thank you for that. The next question relates to sort of the theme of question is sort of data processing relationships. Particularly, we've had quite a few questions of, you know, if we outsource the data processing to somebody else who focus on that for us, does that mean that we don't need to comply with POPIA? And we've also got a few questions relating to different entities within a major group. You know, do you want them to have different agreements, whether you're the responsible party or if they are the data processor or the controller? So just the different relationships there, if you could please address those.
Yes, sure. Yeah, I mean, the scary thing is that if you are the responsible party and you've outsourced your data processing or processing of personal data to a operator, you remain responsible. You are accountable for what they do. And so if the operator to whom you've outsourced has a breach and a major issue, the regulator is going to come knocking on your door, or the data subjects are going to be asking you questions and wanting to be compensated for damages or harm that they've suffered. So that's the scary thing, and that's why you really want to identify who your operators are who process a lot of personal data for you, and enter into good contracts with them and manage that relationship carefully. And then the other question around a group of companies, if they are separate companies, they're separate legal entities, then I think it is important to be very clear whether one in the group is an operator for another who is a responsible party. If it's just one entity with divisions, it's not so important. You might have one division who's processing for another, but clarifying those relationships within a company isn't that important. But certainly if there are multiple entities, then I think it does become important in a group context to know which entity is the responsible party and which is an operator.
John, if I may come in there, I think one of the important things, and John has mentioned the agreements between responsible parties and operators. Remember that it is not just a question of having an agreement. The responsible party is liable to the data subject, and if there's a difficulty particularly with larger companies where their brand can be affected and the reputational risk is high, that can be a very high risk issue. And one of the things about those agreements is that they should contain clauses which relate to how you manage that relationship on an ongoing basis. I think that that is wise. But the other aspect of it is just simply remember that quite often if an incident occurs, the impact of that incident, unless you have a mechanism of knowing about that incident, may be fairly high on an organization, particularly from a reputational perspective. And you need an incident response provision so that you know about that incident that's occurred with an operator as quickly as possible and you can do what is necessary. And I think that the issue here really, and I think we've seen it in rulings from various regulators around the world, it's not an absolute, but if you are not doing things diligently, the regulators definitely are going to come down on you hard. So there might be a breach with an operator. If you have no agreement with them at all, clearly the regulator is going to believe that you've been negligent and not complied with the law. If you have an agreement but you haven't monitored it, they might be say, well, that's very nice, but you didn't do what you were supposed to do. But if you do those things properly, even if there is a breach, and it's quite likely that it happens from more frequently than we think, if you've managed that and you're diligent in that, regulators and very, very importantly, your clients, if you can demonstrate diligence, your reputational risk is so much lower. And I think that that's an important aspect of how you look at impact in that regard. Thanks, John.
Thanks, I agree. Bronwyn, are there another question or series?
Yes, John. Another theme that I've picked up is relating to employee data. So we've got various questions about biometric data collected for employees, race and ethnic details which are required by certain legislation, as well as in terms of health information. If you're collecting a sick note from an employee, does that constitute the processing of health information? So if we could elaborate on just the different types of employee data that could be collected and what would be covered.
Yes, sure, yeah. And so it's very typical that organizations do process special personal information about their employees. And so here what we need to do is check that you're authorized to process each kind of those special personal information. And the way that the authorization works is that it's the law that authorizes you, not the regulator. So you don't have to apply to the regulator. You simply have to check the law and determine whether it authorizes you. And there's a general authorization and then specific authorizations for each kind. So for example, biometric, you would say, okay, we're processing biometric for access control. You would then go and look at the general authorization and it would say, well, if you've got their consent, you're authorized. If you don't have their consent, you might then look at the other general authorizations, like I need to process it to comply with my legal obligations. And that might be where the diversity or race-related information comes in from an employment equity perspective. So you've got to go and look at each one. And that is often a significant job for organizations. And in the employee context, really the best thing to do if you've got lots of employees and you're processing lots of special personal data about them is to have a human resources internal privacy policy that manages and sets out how you process the personal data of employees. And so we've actually, in our program, we've got a module about protecting employee personal information, and we go into a lot of detail in that module. We also give you templates and examples of that internal HR policy and also help you tackle all these questions you're raising around special personal information.
I think another point just there, a lot of people are confusing authorization with consent. Now, consent is a mechanism of authorization, but what John is stressing is that we need to look at the law and see whether you are entitled to process that information. in which event you don't need the consent necessarily. But in some instances, you may need consent. But I again stress, the law is not consent driven, it is principle driven. And we need to look at the justifications for the processing of that and whether they fall into the authorizations which are described in the provisions relating to special information.
All right, thank you, John. We've had a few questions come in relating to PIA and whether or not you know anything about the PIA manual being extended, the deadline. And then we also had a question on the POPIA commencement and the grace period, and given the whole COVID-19 situation, whether or not that might also be extended, and your thoughts on that.
Yes, sure. So if we start with the manual, yeah, every 5 years, certain people get exempted from having a manual, and that 5-year period is due to expire at the end of this year. What has happened in the past is that and it really is has been and still is the responsibility of the South African Human Rights Commission. They've been slow to extend that exemption. And so what should happen is, but before the end of this year, that exemption should be extended and the amounts increased. But I am worried because at the moment, the only sections of POPIA that haven't commenced are relating to who regulates PIA. And so it's still the South African Human Rights Commission and will be at the end of the year. But because that function's been taken away from them, they're not really paying that much attention to it. And the information regulator doesn't have the power to do it. So I'm a little bit worried that'll fall through the gaps. But we're certainly going to push that issue and try and make sure that that exemption is released on time, because it's just crazy if people then start getting PIA manuals when they shouldn't have them. And that just doesn't make sense. And then on the second question, Advocate Pansy Kukulu has been very clear that they will not extend the grace period, given COVID or not COVID. She had many very strong things to say that I saw quoted in the media, where she was making it very clear that there's been lots of time and they will not extend the grace period. So I think it's very unlikely to extend it.
I think there's one other issue related. We've already fallen behind many jurisdictions in data protection, and it would be unwise for an extension to be granted. I mean, they can always, on an ad hoc basis, give a ruling relating to certain instances, but I'm absolutely certain that there won't be a wholesale exemption or extension rather of that grace period. Definitely from my discussions with various people that are involved in it, and just generally the attitude that there has been a long time, there have been lots of delays already in how we've put the law into place. So I agree with John, and it's very unlikely that there will be an extension.
Back to you, Bronwyn. Are there any other questions?
Thanks, John. Yes, we have a few cross-border questions. So the one relates to children's information, which is naturally special information. And what happens if that special information is stored on servers not based in South Africa, and equally relating to cloud processing, whether if the functionality is hosted outside South Africa, would that be considered cross-border processing?
Yes, so the short answer is yes, that if data is hosted outside South Africa, you are transferring data across a border. But the key thing to determine there is which country is it being hosted in, and many data centers and people who are hosting data, they've done it in jurisdictions that have mature, adequate data protection laws. And because of that, you can transfer it. So in other words, the law says you can't transfer personal data, including children's information or special personal data. You can't transfer it across the border unless certain protections are in place, with the most obvious being, well, I'm transferring it to another country like the Netherlands or Ireland that has great data protection laws. And if that's the case, then you can transfer it and there's no issue. Really, the law is trying to stop you from transferring all the data to Swaziland or to Mozambique, or a country that has no data protection law, and then there's no protection. And so really this is in many cases a non-issue. If you look at Microsoft Azure, if you look at Salesforce, if you look at Amazon Web Services, or many of the cloud-based service providers, their servers are located in mature data protection jurisdictions with adequate protection, and therefore it isn't a problem. But it is something that's important to bear in mind and to think about, particularly if you're transferring to countries that might not have adequate data protection laws in place. Running back to you.
Thanks, John. We then have had quite a few questions relating to sort of how to start the process. So is there a checklist that people can measure against POPIA to see, you know, if they're complying? We've also asked, had a few questions asked about gap analysis, and sort of to clarify the distinction between the privacy impact assessment and the gap analysis, although I have shared those links earlier on in the chat. So just sort of how to get started, which department should be the main focus. Yeah.
Yes, no, sure. So just to say it again, and I know it is confusing, what we've just done now is determine the impact of data protection law on your organization. A gap analysis, and maybe what would be worth me doing again is sharing my screen here. So if you just give me a sec, let's go back to the presentation and talk about, so for many people, the next step is to do a gap analysis. And really the gap analysis, what you're doing is you're comparing your organization to a regulatory requirement. And so that regulatory requirement might be POPIA, it might be GDPR, it might be a combination, and you're looking for gaps. So what doesn't my organization do? And that's a gap analysis. And so that regulatory requirement, that's really looking then for checklists. That's where people are looking for checklists or standards or compliance risk management plans or different things in that scenario. That is it's a good question, and there's actually an article on our website where we talk about the different checklists that are available. I don't know if Bronwyn might be able to find it, but otherwise, if you go to our website and search for checklist, you'll see there are different examples there, and there are some checklists you can compare against. But it's also the reason we built our program, because our program creates, it's a compliance framework in many ways, and it gives you the different actions you should be taking. And by working through our program, you're essentially working through checklists at the end of each module. I must say I prefer action lists rather than checklists, because it's much more important to say, well, this is the action we need to take. And have we done that? Yes, we've done that. No, okay, we better do that. No, yes, and you can work through what action needs to happen, rather than a checklist or a gap being, well, you haven't done that. The question is more, well, what do I need to do about it? What action do I need to take? But I think, you know, I'm glad people are asking that question, and that's what our next webinar is about on Tuesday. We're going to be exploring, okay, given everything that we've been through now, which was, must I comply with this? I need an overview. Should I be the information officer, and what's their role? What's the impact on my organization? The next one is saying, okay, well, what action are we going to take? What are we actually going to do now? And that's what we're going to try and help you with on Tuesday. And I'll talk a lot more then about checklists and about different options of really what to do. So Bronwyn, back to you.
Thank you very much, John. We've had an interesting question come in regarding sharing information within an organization. So in a multi-departmental organization, is one department allowed to use personal information that was collected by another department for a different purpose?
Generally speaking, yes. And on my screen, I've just gone to our mapper. If you've got this controller here, this big circle, divisions within a company are all within that same circle. And so I don't think, and it's because if you look at the definition of a processor or an operator, they need to be independent or not under the same authority. And that's why divisions within an entity really all are within this circle. So it's not so much about sharing amongst them, but obviously the question still remains is all that processing still in accordance with the principles? Yeah, but it becomes less about who's sharing with who within a legal entity or within one controller.
Bronwyn, I think if I understood the question, it indicated that using the information for a different purpose. Now, if that is the case, clearly you have to be careful because you need to, when you collect information, you need to have the purpose set out. And there is a prohibition, well, not a prohibition, but there's a regulation of using information for further processing where it does not, where it's incompatible with the purpose for which it was collected. So one has to be a little bit careful. If you, for instance, if you collect information to open a bank account and you give that information to marketers or the sellers of insurance, that might not fall within the purpose for which you provided that information. So one has to be a bit more careful about that. It's not really part of what we're talking about now, but I think that just to answer that question, be careful of the issue of purpose.
Yes, and Mark, I agree. That's a classic example of applying the principles to using information within a controller. Yeah, that's a good point. So I think I'm just looking at the time here, and I think you know, we've covered many questions already, but I think we can continue to answer questions. And so you're welcome to stay for as long as you want, or you can leave. But please join us on Tuesday. We'll be, as I say, tackling what action to take. And so you're welcome to leave, or you can stay. We'll just continue answering some questions for about another 10 minutes or so. Bronwyn, are there more questions? Maybe I should have asked you that first. Yeah.
Hi, John. Yes, there's plenty of questions. They are becoming a little bit more specific, but I think there's one that you can answer. We have a question about a software as a service-based company, and they want to know in terms of counting the number of customers. Is it their customers or their customers' customers? So the end user, as it were. They want to know whether that would be considered. And then sort of related to numbers and counting, we've got for POPIA assessment, in a group context, do you consider the number of employees and turnover on an individual company basis or at a consolidated level?
Yeah, those are good questions. So the SaaS company, you typically would be an operator for a responsible party. And so you've got to separate the impact on you versus on your customer. So maybe, yeah, so they're not your customers, they're your customers' customers. And so the impact is high on your controller, it's on them, but not necessarily on you. But obviously, if you're the provider and processing for that controller, and you're providing, you're processing all their data subjects information, there's going to be a lot of heat on you from the controller. They're going to be very concerned about what you're doing, and that agreement's going to become very important. But they're going to be very worried about it. So it then raises and pushes the impact up on you. And then I think, you know, in a group context, in terms of the number of customers, I think and I think Mark's made this point is also that it really depends on how different those companies are in a group. Sometimes all the companies in a group do a very similar thing, but sometimes their activities are very different. And then you've really got to be looking at them as separate entities and look at them in isolation, and particularly where they're a responsible party in their own right, and looking at the impacts in that context. And so sometimes you look at a group of companies, there'll be 10 companies. Sometimes the impact is medium to low on 9 of them, but then they have one company that does all the direct marketing for the group. And that's obviously going to be high impact in that context. So it's to look at it in that way, I think. Back to you, Bronwyn.
Sure, John. We've had another question in relating to sort of GDPR and the relation to POPIA. So the first part of the question is, if you're GDPR compliant, are you POPIA compliant? And then another question related to the GDPR is relating to notification of breaches. So if there is a breach, do you need to notify the data subject, and how that looks in comparison to the GDPR?
That's a good question. So if you're GDPR compliant, you're 90% of the way there with POPIA. There are a few extra things that you need to do with POPIA, but it's not significant. If it's 90-10, I'd give the split. And but certainly you're a long way there, which is good news. And then on the incident response and reporting, the wording in the GDPR and POPIA are very similar. Essentially, if you've had a breach, you need to notify the authorities and you need to notify all data subjects who are involved. There are a few nuances in the wording, and you can get into some long debates about what that means in terms of those differences. But the principle is the same. It's really, if you've had a breach and you got a reasonable suspicion that somebody did access personal data or managed to make a copy of it, then you do need to notify. Yeah, I think going into a detailed discussion about the real nuances between the two is maybe beyond the scope of today's workshop.
I think though, John, that one of the things that must be understood in that principle is that if there's a data breach, remember that the information is owned by the data subject. And part of the reason for breach notification is to allow the data subject as well to protect themselves against other criminal activity that might happen using their personal information, or alternatively, just simply because they need to ensure that they know what is happening with their information. They're entitled to know what is happening with their information. And if there's been a breach, it is important that they do. So breach notification is something that's been around for quite some time in different jurisdictions. And it is something that I think is very, very important to look at in how you might deal with any breach at all. Your incident response is a very, very important aspect of how you would deal with it. And one of the things that we've seen is, for instance, the Equifax matter, where they hid it away for a while. Well, Equifax has been hit very hard from a regulatory point of view because of the fact that they did not notify the data subjects as quickly as they should have. Thank you.
Mark, I think to add to that, I agree, is that you've got a tough decision to make, in that if you decide not to notify and you get caught out, you look really silly. Uber got caught in this as well, and Uber had a breach that they tried to put the sweep under the carpet and they got caught, and it really then backfires on you. So if you are going to sweep it under the carpet, and I'm not suggesting that you do, make sure you properly sweep it under the carpet, because if you get caught, you're going to be in serious trouble, both reputationally and from regulators. Bronwyn, back to you.
Thank you, John. We have another question relating to sort of the way data is processed. So the first question relates to children's information and the fact that they collect it on forms, but they don't do anything more than that. It's just the name and surname of the child that gets filled in and nothing more. And then we have another question that relates in that they're upgrading systems and moving data from one to the other, and whether that would be processing of information.
So unfortunately, processing is defined very broadly. If you're doing anything with the data, you are processing it. So if you're capturing on a form, that's processing. If you're transferring one system to another, you're also processing. And but obviously we want to take a very practical approach. So you're obviously going to say to yourself in the scenario of a form with the children, okay, is it a physical or electronic form? If it's a physical form, then what harm could somebody suffer from this? And you would obviously then say, well, jeepers, okay, if someone got this pile of forms, they might be able to now know which children are at which schools, and names, and So we need to secure those forms. Let's put them in a secure filing cabinet, make sure only a few people can access them. And that's possibly all you need to do, because you've then protected that information, and that would be fine. So yeah, it's a broad net. If you do anything with personal data, the law applies, but it doesn't necessarily mean that you're going to have a lot of obligations. If it's very low touch, and I guess that's another factor in determining the impact is, are you low touch or high touch in terms of that personal data? Are you just moving it between systems? Are you just storing it? Versus are you actually doing data analytics on the data? Are you cleaning the data? How intensively are you processing it is an important factor. Back to you, Roman.
Thanks, John. The next question relates to sort of conflict between different pieces of legislation. So at a local perspective in terms of FICA, how does that relate to POPIA and what the relationship is there? But then equally in terms of data protection legislation on a more global perspective, you know, what takes precedence? If you're a company in South Africa providing services to the US and the UK and they insist on sort of using GDPR, but the bulk of people reside in South Africa, what then should you be looking at? What should be taking preference?
Yeah, it's a great question, and really our slides, and we deal with this in the module of our program, talking about the global view, because what often the scenario is that people have multiple data protection laws they need to comply with, multiple other laws, and then there's also related issues, and so you end up with a really tricky situation of significant overlaps. And that's what we try to depict here, of focusing on the common 80% between laws, but then also talking about the conflict, what you're wanting to achieve here. And maybe, no, I don't have a slide there, but really what the point is here is that it's whichever has the highest standard. So POPIA says that if there's a conflict, whichever gives the data subject the greatest protection, that would be the law that prevails. And so maybe to give you an example, in healthcare, there are many healthcare laws that require a doctor to keep information confidential. And often those requirements are stricter than what is in POPIA. And in that scenario, POPIA would apply. And so it becomes a very tricky situation if you've got not only multiple data protection laws, but multiple other laws that contain confidentiality and privacy related provisions, to work through all of that and find out which one protects the person the most is not an easy task. And we've helped some organizations create a matrix which tries to set that all out on tables so that you're able to then pick the right one. And I mean, both in terms of direct marketing and for credit bureaus, it's a scenario like that where you've got multiple laws like National Credit Act, their codes, their standards, there's the Consumer Protection Act. There are all these different laws that have to be taken into account. So I'm afraid I'm doing a good job of explaining the problem without really giving you solutions. The solution is tough. It's pretty hard to come up with that full picture that enables you to give that scenario. But certainly the key factor being it's that whichever gives the data subject the most protection is the law that applies. Back to you, Rowan.
Thanks, John. The next question I'd like to ask sort of relates to consent. We had two questions relating to this. The first was about children and the fact that they're under 18. Then, you know, if you've got a parent or guardian who would be consenting on their behalf, but then also sort of similar to that, what does POPIA say about the power of attorney? You know, you've given consent to an attorney to do something for you, maybe for banking details or related to that. How does POPIA address that sort of consent?
So I think that the power of attorney scenario is a slightly different issue. That's just really somebody granting somebody the power or agency to do something on their behalf. It's not really a data protection issue. But certainly with children, that's an interesting one, is that one of the ways you are authorized to process children's information is if you have a competent person's consent. And a competent person, it was specifically used, that term, so that it could be broader than just a parent. But classically, if you want to process children's information, getting the parents' consent is one of the ways to get authorization. But as Mark pointed out, there are other ways to get authorization as well. For example, if it's in the best interests of the child, you can as well. Yeah, I don't know if I've answered the question, yeah, those are some of the factors to be thinking about. Oh, the other thought that I didn't raise actually in the polls is that one of the tricky things about multiple jurisdictions is that different countries regard children as being children at different ages. And so in Europe, it's really 16. In South Africa, it's 18. And in America, 13 is a key age. And that certainly is a bit of a problem because it depends on how young the child is, has different impacts and different considerations to take into account.
And just coming back to the issue of competent person, as John said, typically it's going to be a parent or guardian that is the competent person. But it is the competent person in the context of where it is. So for instance, a person under 18, a girl under 18 or a lady under 18, can choose to have an abortion, and she doesn't need the consent of her parents. That the competent person there might be, she might not want her parents to know. The competent person would be a medical practitioner. Thanks, Bronwyn.
Thanks, Mark, for adding to that. I think then the sort of last theme of question that I have relates to penalties in POPIA and whether the company would be penalized or specific individuals. John, I think we did touch on this in previous webinars, but perhaps you could just touch on it again.
Yeah, sure. And essentially, it all comes down to who committed the offense. And I think this is another important point, is that globally, countries are trying to decriminalize data protection. In other words, it shouldn't be a criminal offense if you get it wrong. It is unlawful, but not illegal. And unlawful still has consequences, but there shouldn't be, it shouldn't be criminalized. And unfortunately, there are a few crimes in POPIA, but they're actually very limited compared to what it could be. And if you look at the GDPR, for example, I don't think there's a single crime. There's no criminal sanction in it. So it's very unlikely that they will end up, as we've mentioned, in being in jail. But if you look at the data subject suing somebody for damages, it would really be, they'd be trying to sue somebody or hold somebody liable that was the person who caused the damage. And 9 times out of 10, it's going to be the controller or the responsible party. That's who the data subject will go after, because the responsible party will probably have money, have deep pockets, so that would make sense. That's the person to go after. And the law also really makes them accountable. It's not the individuals within the organization, it's the body. But to give you an example where somebody can be held personally liable, there are instances where a nurse in a hospital has given records to journalists, for example. And in that scenario, the person whose records were disclosed could suffer harm, and they then certainly would have a claim against the nurse and the hospital, and would probably try and hold both liable. And so it's certainly possible, but I think 9 times out of 10, the data subject's going to go after the responsible party. Back to you, Bronwyn.
Thanks, John. We've had a question that's cropped up from one of the previous questions, and it's about children's data again, and where a parent has consented and the child now reaches majority, must the processing stop until the child has now consented to the processing? Yeah, it's quite specific, I know.
Yeah, no, it's a good question. I think, yeah, it probably does change, and I think you then do have to revisit the principles. So we've got to go back to now, okay, the person's no longer a child, they're an adult. Do we have a lawful ground for processing? And there are 7 or so of them. One is, have we got consent, in which case we would go back and get the consent of that person. But you might well be able to rely on one of the other grounds for lawful processing. But that is a tricky question, which is difficult to answer in short. And I think, Bronwyn, just looking at the time, we've been going for an hour and 25 minutes. I think maybe we should leave it there. I can see that there are a lot more questions, and I'm sorry if we haven't got to your specific questions. But I think we have managed to answer many, and thank you very much for attending. And sure, we've still got 100 people who've stuck around to this point, which is great. But thank you very much for attending. And yeah, please register for Tuesday next week. We can answer some more questions then. And we look forward to seeing you there. So thank you very much to Mark. Thank you very much to Bronwyn. Thank you for your contributions.
Welcome, John, and goodbye to everybody. I just give you some news, breaking news, and that is the cold front has hit the Cape Town with a vengeance. If you know of anybody whose name is Noah and they've been doing some building work, you've got my email address. That's how bad it is. Cheers.
Great. Yes. So thanks very much for attending, and thanks for ending on that light note. Enjoy the rest of your day.